mahakamani kusikiliza kesi dhidi ya mbunge wa Juja George Koimburi ambaye anakabiliwa na mashtaka 7 ya matumizi mabaya ya kompyuta na uhalifu wa mtandaoni.
Proceedings against him on account of the same facts. More importantly, I refer to this case. More importantly, where either of the subsections under section 87A and B of the case are invoked, an aggrieved party has sufficient avenues of other rights to further his rights under the Bill of Rights. The act of likelihood to reopen the case against an accused person should not be a bar under section 87 of the CPC. The constitutional provision of Article 4 reserves fair trial until final judgment is pronounced by the court. It is therefore immaterial for the court under section 87 of the CPC to prohibit withdrawal on grounds of accused suffering any prejudice. If the charges would suffer prejudice if fresh charges are to be filed by the state. That is the case of Republic versus Leonard Senketo 2019. But the court is not civil of the old matters to determine the reasons for withdrawal of the case and at what stage the same was withdrawn. The court, however, under section 87 of the CPC is aware that the ODPP have power to withdraw and reinstate the suit or bring fresh and similar charges before the court over the same set of facts. The court shall not bar any subsequent proceedings as presented by virtue of that section. The same case proceeded to say the role of the court is clearly defined under Article 51 of the Constitution, solely to decide fairly and independently on cases brought and filed by respective parties, including the state. The jurisdiction of subordinate courts is well defined in the respective statutes and must therefore act within the bounds of that authority. The trial court, on receiving the request under section 87A and B, has power to judicially consider elements of the provisions and proceed to give effect in the manner stated in the court. That is the same case of Republic versus Leonard Senketo. Bringing fresh charges over the same facts fall within the ambit of section 87A of the CPC. On the additional charge under section 121 of the Penal Code that is not known to the accused will have his chance to be served with documents relating to the suit as to enable him. I've already made my ruling. I cannot consider the ones you're bringing now.
No, it does not relate to this.
Okay.
It's another subsequent application.
Oh, okay. So the accused will have his chance to be served with the documents relating to the suit as to enable him defend himself appropriately. This includes the record or information that is deemed to have so failed to attend court. This is the plea stage, and it is only after the charges have been read to the accused that the relevant documents can be supplied to the accused by way of pre-trial to enable him to present an appropriate defense as required under Article 50 of the Constitution. If any constitutional breaches are foreseen, then the same can be raised at the appropriate forum. The court finds no prejudice will be suffered as the accused will have ample time to prepare and defend himself. That is to say, the criminal objection is dismissed, you have a right to appeal.
Yeah, we appreciate the ruling of the court and ask the court to grant us a type of proceedings and the ruling. We would wish to launch an appeal on the count of the court's decision. We shall however proceed to undertake the dismissal today. Okay. We shall raise the next objection as already there.
Okay.
You're most obliged.
I believe everybody is there. I just want to write quorum as before.
Yes.
No.
You have added someone.
You've added someone.
Yes.
Okay. Quorum as before, and then I add one more name. You said your name is? Still for the accused, eh?
Yes, sir.
Okay.
For purposes of order, then it can be called record that you're being led by Mr. Manze, Wasilia.
Okay.
For order purposes.
So, I believe we proceed to plea.
George Koimburi, Section 345 as read Section 349 of the Penal Code, the particulars being that between the months of November and December 1994, with the intent to receive forged a Kenya National Examination Council certificate, to wit, a Kenya Certificate of Secondary Education Certificate, serial number 2015684, purporting it to be a genuine and duly signed certificate issued by the Kenya National Examination Council. True or not true? You have a second count, that is forgery contrary to section 345, as read in section 349 of the Penal Code, the particulars being that between September 2011 and April 2012, at an unknown time and place within the Republic of Kenya with the intent to receive, forged Jomo Kenyatta University of Agriculture and Technology certificate of participation in the East Africa Universities Accession Project, serial number JKU/Kenneth/E1/2011 to 2012/C6, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a third count, that is forgery contrary to section 345 as read with section 349 of the Penal Code. The particulars being that between September 2011 and April 2012, at an unknown time and place within the Republic of Kenya with the intent to receive, forged the Jomo Kenyatta University of Agriculture and Technology Academic Excellence Certificate from the Department of School of Human Resource Development, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a fourth count, that is uttering a false document contrary to section 353 of the Penal Code, the particulars being that on the 8th of March 2021, at the Ethics and Anti-Corruption Commission, knowingly and fraudulently uttered a forged Kenya National Examination Council certificate, to wit, a Kenya Certificate of Secondary Education Certificate, serial number 2015684, purporting it to be a genuine and duly signed certificate issued by the Kenya National Examination Council. True or not true? You have a fifth count, that is uttering a false document contrary to section 353 of the Penal Code. The particulars being that on the 8th day of March 2021, at the Ethics and Anti-Corruption Commission, knowingly and fraudulently uttered a forged Jomo Kenyatta University of Agriculture and Technology certificate of participation in the East African Universities Accession Project, serial number JKU/Kenneth/E1/2011 to 2012/C6, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a sixth count, that is uttering a false document contrary to section 353 of the Penal Code. The particulars of the offense being that on the 8th of March 2021 at the Ethics and Anti-Corruption Commission, officers knowingly and fraudulently uttered a forged Jomo Kenyatta University of Agriculture and Technology Academic Excellence Certificate from the Department of School of Human Resource Development, purporting it to be a genuine and duly signed certificate issued by the Jomo Kenyatta University of Agriculture and Technology. True or not true? You have a second count, that is failing.
You know, that's where we are. Before the accused person pleads to count number 7, we would wish the court to make a determination, and it's a legal question, whether that count discloses an offense. The accused person is charged with the offense of failing to attend court, contrary to section 121, subsection 1, paragraph I. You know, the reading of that section in the Penal Code, it's our humble submission that the same does not disclose an offense that can warrant the accused person to plead to. Your Honor, our application is backed by Article 50, Clause 2, Paragraph N of the Constitution, and that's where we'll begin. And I'll make brief submissions, and then I'll invite my learned friends to proceed. You know, that section says that every accused person has the right to a fair trial, which includes the right not to be convicted for an offense, for an act or omission that at the time it was committed or omitted was not an offense in Kenya. You know, the basis of that provision is the notorious Latin maxim that nurem crimen sine lege. No one shall be charged on offense if the offense at the time of its alleged occurrence was not an offense in Kenya. I am trying to look for the penal code, Your Honor. And since I don't seem to be getting one from the grave book, allow me to fish it out from my phone. Your Honor, got it. You know, section 221 provides these are offenses relating to judicial proceedings. A person who commits any other act of intentional disrespect to any judicial proceedings or to any person before whom such proceedings is being heard spelling is H-A-D. I think Parliament was looking at H-E-A-R-D, and we cannot legislate, or taken is guilty of an offense and is liable to imprisonment for 3 years. The ingredients of this offense, Your Honor, is intentional disrespect to any judicial proceedings or to any persons, that is yourself or the previous magistrate, who such proceedings is being heard. The judge is failing to attend. The judge does not square out with the law. And that is a prejudice our client will suffer if he is allowed to plead to an offense that is alien in law. And of course, you may not doubt the mischief by the DPP, so that this can form the basis upon which our client will be denied bail. Of course, they will say there are compelling reasons to deny our client bail on the basis of previous absconding. And therefore, this application itself is also anticipating the ability of our client to enjoy the rights under Article 49.
Na hiyo ni kesi inayoendelea inayomhusu mbunge wa Juja George Koimburi, ambapo anakabiliwa na mashtaka huko kotini.